up with rules, it will look at law. There could be laws relating court fee, there could be laws relating to many things that impinge upon, but at the same time, there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expensive. It says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58 read with 191 gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. So, but what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
I bow to your lordship. That is why I said it's a ping pong entry, and that is what happens when you look at entry 55. My position is very different from Mr. Salahuddin's position.
Ping pong can go on endlessly. Where does your ping pong end?
I'll come.
I think it's just one way. It doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would have understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal, as you had mentioned earlier? So that's why, is there any significance of the word practice, and whether intra-court appeal is for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhel who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court
yes,
also.
I can. But let me just read those, because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन sir, आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked, what is your opinion? Without my opinion, it was sent to the...
लेकिन सर, आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप सर. Page 9 पे.
चलो मैं उसका जवाब अभी जो खत्म होगा तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhel's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion. I'll read the last 4 lines. As the issue involved is in this petition is identical to involved in constitutional petition number so and so, therefore let it be placed before the honorable. Now, on this, a dissent was done by uh, Justice Hassan Azhar Rizvi. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same content. It is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned, so both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution, by its clause 1, ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of Section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note two things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number two is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhel had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the law reforms ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge, you will.
Sorry?
Referee
As he referee judge, sir. Page 20, sir. I may read. Para 3 measure of context de do. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhel, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184.3 of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution such that Section 3 of the ordinance is a valid legislation. Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
If I may request you kindly read the whole.
Should I read the whole, sir?
I think
Ji,
that
ji,
may
ji, ji.
provide
But,
some-
ji, sir, sir.
Some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its pist and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the others in this list, all courts including the High Court. Right of appeal can, for present purposes, be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right, which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in respectively the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of course, contained specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it says.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, and it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading
Which
it.
actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision,
Yes,
given in the first instance by one member of the court. The first as well as the second decision remains the decision of the court. And if you look at Order 5, Rule 2 in the rules,
yes, there's a chamber
there is
appeal.
a chamber, it doesn't say appeal, it says for reconsideration
Yes.
to a three-member bench. So three judges, if you see Order 5, Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having
So no, Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
as registrar.
From
Agla pade na.
to the judges in chambers.
That's
It's an
right.
appeal.
And then there is
See,
from a single
that's
judge
an
to three judges.
administrative order, and that's an administrative appeal.
But it's still an
not
appeal.
a judicial order.
It's still an appeal, and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my learned colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single
Can you
judge.
tell us where are you reading from?
Order
Sir,
5,
Rule 2, Order 5, sir, Supreme Court rules.
the power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If your Lordship may kindly see page 25, para 20, para 12.
Para 12.
Ji, sir. Ji, sir.
Ji.
Page 25. In view of the above discussion, I am in no doubt that the question referred to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो है in contrast my learned colleague Sayyid Hassan Azhar Rizvi has rightly noted is in order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
See, Mr. Counsel, the thing is that you are, of course, referring to my order.
Ji, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I'm picking up on the point that you think flows from this order.
Ji.
Seems to me, you respect that it cannot conceivably flow from this order. The reason is that the issue before the court or before me as the referee judge was a right of appeal conferred by statute, right? And as you have read, I have noted 2 kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of the current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, and that is certainly not what this order was about, but would be incorrect. Why? For 2 reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I
But
think it can.
secondly, there's just one more.
Yes.
Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would follow from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My lord,
In relation to Section 5 now, we
My
are the
lord,
context
my
here
lord,
is Section
my
5.
lord.
So tomorrow, the full court amends the Supreme Court rules and creates a right of appeal. Can
my
it do
lord,
that?
my lord, I make two alternative arguments when it comes to the legislative importance
Mr.
of
Faisal,
appeal.
before
Ji,
going to
ji, ji.
answer the question of
Ji,
my lord,
ji.
please complete that page 18, paragraph number 16 of my lord Hassan Rizvi. This is
Sorry?
very interesting paragraph 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है आई एम सॉरी दिस इज आल्सो क्रूशियल टू दिस मैं पेज 18 पे हूँ सर पैरा 16 it's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Paragraph 16. Surprisingly, this question, page 18, surprisingly, this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tewana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declare laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write,
Harmonious
whether reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-court.
Intra-court. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184.3 are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous
No, but
power
you see,
exercise.
this Order 5, Rule 2 that you read, even
Yes.
though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the parties, and the rules are providing for that appeal.
Yes, yes. So this is one way I can, that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes, yes.
Okay.
Yes.
And why
They
do-
are not always restrictive, my lord.
If I may follow what my learned colleague has said with regard to Order 5, Why
I
didn't they
can't
use
hear
the
you.
word?
I can't hear you. I mean, I can't hear you. So
I'm so sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
Include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So
If
this
it were
is a
an
review?
appeal, this is not a review.
Reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
Review, practice and procedure में review का power confer कर दी तूने.
ये देखिए ना,
अगर
उसने deliberately ये
in an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of.
For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as well, or that particular question as articulated was not put to them.
Yes, yes.
So that can the Chief Justice then say, can you all three sit together and decide it? Since now the possibility of a hung court will not arise. It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. There's no, I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge,
Yes.
it says that the appeal would go to a larger bench. Now, I just, want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? Traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord,
is there
For instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and 1 judge has been removed, 3 have been added. So that judge here, himself being bench, is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this
There
word
are two
reconsideration.
parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is
against
against
the
it.
order of the registrar in
But
chamber.
that is
And
against
suppose if we
registrar.
were to consider Section 5 and
That is why
consider it as
the
a
word-
reconsideration,
That is why the word reconsideration has been
Does-
used, in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it's not just like an appeal.
But let us see.
and if we were to just say that Section 5 is a reconsideration, and
Sir,
let's
may I-
not in the word appeal,
Let's
could it
just
not
focus
then
on
pass
this
the
word
muster?
reconsideration. What is happening? Sir, मैं एक बात
That is why
मैं एक बात
it is not an appeal.